Thank you very much, Brianna. Thank you all for being here. We really appreciate it. We're here today to announce a first-of-its-kind resolution that puts millions of dollars back in the pockets of thousands of Washingtonians and reforms the charity care practices of multiple hospitals around our state. Washington State's charity care laws require hospitals to provide access for free or reduced cost medical care to low-income patients who need it. It's the kind of thing that should be in line with the mission of a hospital like St. Joseph Medical Center in Tacoma. St. Joseph was founded in 1891 by the Sisters of St. Francis, who, quoting from their website, quote, "minister to all people regardless of race, religion, or financial status." In 2017, my office filed a lawsuit against St. Joseph, alleging the hospital repeatedly violated Washington State's Consumer Protection Act by withholding charity care from tens of thousands of eligible low-income patients from 2012 through 2017. We filed that lawsuit against a single hospital, that was St. Joseph's. But today we're here to announce a resolution that involves 8 CHI Franciscan hospitals, including St. Joseph's. So I just want to emphasize that. The original lawsuit was against St. Joseph's. This resolution is more global and encompasses all of those hospitals. CHI Franciscan, as you know, is the parent company that owns St. Joseph and operates hospitals throughout the South Puget Sound area, for the South King County, Pierce, and Kitsap counties. CHI Franciscan entered into a legally binding agreement covering all 8 of its Washington acute care hospitals, and that agreement will do the following: reform its charity care practices, pay more than $2 million in direct restitution to patients, pay my office approximately $2.5 million, provide up to $20 million of debt forgiveness to Washington patients who qualified for charity care but did not receive it, restore the credit of patients if their credit suffered as a result of the unlawful conduct, and expand charity care eligibility going forward. So I want to make some introductions here of folks. So first, I'm joined by an Assistant Attorney General in my Consumer Protection Division. That's Audrey Udishin. Audrey has spent a lot of time working on this. Where's Audrey? Is right to my left. So Audrey was hired in 2015. In fact, she was specifically hired to do work on medical hospital type issues. That was an interest of mine and for the Consumer Protection Division. And she began investigating this case shortly after she started. So today's the culmination of a lot of hard work from Audrey, the team, investigators, and many others in the Consumer Protection Division. Also joined to my right by Representative Lori Jenkins, who represents the Tacoma area, who we greatly appreciate after adjourning last night at 11:58 p.m., being back here early in the morning, but it shows her intense interest in this subject, and she's been at the forefront at the state legislature on proposing and passing legislation related to medical care debt and to charity care over the past 2 sessions. So thanks so much for coming down this morning. We really appreciate. I also want to thank Diane Sosny, who could not be here today. She's with SEIU 1199 Northwest, and her team for their help on this issue and helping to bring these issues forward to our office. We have a couple folks from that organization who are with us here today, Phoebe Rounds and Laura Dougherty, who are both here today, and we really appreciate their assistance. Also joined by Julia Kellison. She's an attorney with Northwest Justice Project, and her focus is around charity care issues, as well as Ann Logerfo, who wrote a report about charity care issues and the impact that can have across our state on individuals in very significant ways. I'm going to briefly go over what charity care is, just so folks understand what it is, what the obligations are, what our case was against St. Joseph, how our resolution holds them accountable and ensures that patients at all 8 of CHI Franciscan acute care hospitals will get the assistance they deserve. And Representative Jenkins will say a few words, and then we'll take your questions. So just by way of background, all hospitals, public, private, for-profit, not-for-profit, are required by Washington state law to make charity care accessible to individuals who are at or below 200% of the federal poverty guidelines. It's a requirement in law. I'll give you some specific requirements under the law. Number 1, you must notify patients of the availability of charity care, that it exists. You have to notify patients of that. Number 2, you need to screen patients for charity care eligibility before beginning or attempting to collect payment. And third, you have to limit the income verification materials to a single document. In other words, you can't overburden folks with lots of paperwork in order to get the charity care that they are entitled to. Our lawsuit asserted that St. Joseph violated all of these requirements. We'll give you some examples. For example, employees were trained to demand payment up front before providing information about charity care. Training materials instructed staff to, and I'm quoting from the training materials, to, quote, avoid phrases that give patients the option to not pay. One former employee reported they were told to, quote, never volunteer information about St. Joseph's charity care program to patients, even if they were obviously low income or homeless. That former employee also reported that they were instructed to, quote, encourage patients to pay the deposits by indicating that I could only provide them with a charity care application if they paid a deposit first. Our investigation revealed that St. Joseph's senior management received notice of these problems but failed to take sufficient corrective action. One complaint came from one of St. Joseph's own employees who received notice of a debt collection lawsuit against her despite being assured that her accounts were on hold while her charity care application was being processed. The vice president called this complaint, quote, terrible news from a very credible employee, and acknowledged that echoed complaints from the hospital's employees union that similar issues were happening, quote, on a regular basis. Some of these practices continued until my office began our investigation. We know patients who struggle to decide whether to get life-saving care because of these practices. In a document obtained in our investigation, one executive wrote to a colleague, quote, I'm afraid this is going to backfire on us if we are not very careful very soon. That statement turned out to be correct. Today's resolution rights a wrong committed against thousands of patients across Washington state and ensures this does not happen again at the CHI Franciscan Hospital. Our resolution could impact any patient who received care at those 8 CHI Franciscan hospitals between 2012 and 2017. Those hospitals are St. Elizabeth Hospital in Enumclaw, St. Francis in Federal Way, St. Anthony in Gig Harbor, St. Clair in Lakewood, St. Joseph, of course, in Tacoma, Harrison Medical Center in Bremerton, Harrison Medical Center in Silverdale, and Highline Medical Center in Burien. Now, CHI Franciscan must perform a multifaceted process to ensure that every patient has the opportunity to receive the relief that they deserve. All uninsured patients, and that will be tens of thousands of individuals statewide, will automatically receive a notice in the mail which will include instructions on how to receive refunds, debt relief, or both if they were eligible at the time they received care. So right now, a third party is reviewing thousands of patient accounts to determine eligibility for automatic relief from their unfair medical debt. So the goal is to review all these records going back in time. It's a lengthy, time-consuming process, but the goal is to identify folks who would have been qualified for charity care and didn't get it and give them automatic relief in the form of a check or debt relief. So restitution, for example, that third-party review has already identified 5,451 uninsured charity care eligible patients who paid some or all of their hospital bills. CHI Franciscan must give those 5,400 patients automatic refunds. That totals $2.2 million. Those folks who just get a check in the mail, they don't need to do anything else. That's happening. Debt relief is a key component. In other words, someone has a debt. They could not, for example, pay their hospital bill. Now they have a debt. We're in the process of determining how many people have been saddled with debt because of the unlawful conduct. An estimated 7,000 uninsured patients owing a total of about $26 million could be impacted. All of these patient accounts are being reviewed to determine whether they should have received charity care. It's our estimate, and again I want to emphasize this is an estimate, that CHI Franciscan will be required to provide up to $20 million in automatic debt forgiveness for these patients. Total's not known, they're going through that process, but it's up to about $20 million that we would estimate will be automatic debt forgiveness where the patient doesn't need to do anything. That's going to happen automatically. Now remember, these are patients who should not have had a debt in the first place because they were eligible for charity care. If patients partially paid their bills, they may receive, of course, both a refund for what they paid and a debt forgiveness on what they still owe. Another key aspect about this resolution that goes beyond the money, which is significant, that goes beyond the debt forgiveness, which is obviously significant as well, is making sure that adverse credit implications for these individuals associated with this debt is taken care of. So unfair medical debt can also destroy someone's credit, and that can have far-reaching effects on many aspects of their lives. Our agreement requires CHI Franciscan to to do their part to repair the credit reports of these patients that may be impacted by the unlawful practices. Specifically, CHI must notify the credit reporting bureaus that their accounts are paid in full. Additionally, CHI must request that the bureaus delete any reports indicating the medical bills were delinquent. Any patient who received care from the 8 CHI Franciscan hospitals who is eligible for charity care when they receive treatment will have the opportunity to receive full restitution for out-of-pocket expenses, debt relief, or both. And this includes insured patients who are eligible. And last, I want to talk through some reforms, additional reforms that will take place as a result of this resolution in this case. Today's resolution also ensures that CHI hospitals will provide charity care to the patients who need it. It requires CHI to make patients aware of the availability of charity care before attempting to collect payment, to refrain from collecting payment from patients who appear to be qualified for charity care or express interest in applying for charity care until they have an opportunity to apply. And it only requires patients supply one form of documentation to verify their income. Additionally, all 8 hospitals will continue to provide charity care to patients at or below 300% of the poverty line, which is 100% more than state law requires, and they're required to do that for the next 5 years. The subject of our lawsuit, St. Joseph, so those apply to everybody at CHI hospitals. The subject of our lawsuit, St. Joseph, has additional requirements. St. Joseph must take proactive measures to ensure that current and future patients are aware of their rights to access charity care. And here are a few things that St. Joseph's must do. They must post information about the availability of charity care on its website and social media platforms. They must provide notice of today's announcement in public areas of all of the hospital. They must provide notice of the settlement and of patients' right to apply for charity care through media outlets. They must pay $100,000 administered by my office toward conducting outreach related to charity care at Washington hospitals, and they must conduct public meetings to inform community members of the settlement and the availability of charity care. So to recap, CHI Franciscan has now entered into a legally binding agreement at all 8 of its Washington state hospitals to reform its charity care practices, pay more than $2 million back to individuals in the form of restitution, pay my office approximately $2.5 million, provide up to $20 million by our best estimate of debt forgiveness to Washington patients who qualified for charity care but did not receive it, restore the credit of individuals if their credit suffered as a result of this unlawful conduct, and lastly, expand charity care eligibility. It's a big resolution. It's a big case. We don't believe our office has ever had a case like this. The scope is extremely broad, as you can sense from the relief in this case. The final numbers of the impact won't be known for some time as that third party does its review of all these patients. The key here is we're going to be going through an extensive process to make sure everybody who is eligible for charity care is made whole through debt forgiveness or a check back to them, or both if that's appropriate. So it's a big resolution. I'm really proud of the team who's been at this for a long, long time. Again, this is a case that started against St. Joseph's, but involves multiple hospitals across the state, and will be transformative for many people who are struggling from the medical debt that is impacting their lives. With that, I want to turn to Representative Jenkins, who, again, I really appreciate her taking time this morning to come to this press conference. She was at our press conference in Tacoma, as I recall, back in a couple years ago when we first announced this. And so this has been an issue I know she cares very deeply about on a personal level. She's been a leader on this issue across our state and the state legislature. And with that, Representative Jenkins.
Thank you, Attorney General Ferguson. I just was thinking, this is one of the reasons why I'm very proud to always tell people that I'm a former Assistant Attorney General, because the incredible work that is done by the Attorney General's office to protect people who are victimized in the fashion that people were in my district, for the most part, my district. And the advocates here, I've worked with all the advocates here on charity care issues. So I am just so pleased to see this settlement. And I guess I'll apologize because I've had about 4 hours of sleep over the last few days, so I will try not to ramble very much on this, but I can't remember if it was 2 or 3 years ago when I started hearing from constituents about things that were happening to them at the hospital about not being provided charity care, and actually people who worked, we heard about this from Attorney General Ferguson, people who were actually working in the Franciscan system who needed health care and who their employer was sending them to collections and not offering them, even talking about charity care with them. So I started hearing about this some time ago, and then the AG's office got involved and started investigating. And I'm hoping that we do not see this this activity anywhere else in the state of Washington. But this is why we have kind of continually looked to improve our charity care laws, to make sure that people are getting noticed, to make sure that they're not being dissuaded from applying for charity care when they need it by being given 17 and 20-page charity care application forms. Right now, we have legislation that says it needs to be a single form. Actually, I would say the Hospital Association, rather than doing legislation, agreed to help get their hospitals on board with that. I just want to comment finally that medical debt is a huge issue in this country and in this state. It's the #1 reason for bankruptcy. And that's why this year I worked with a lot of the partners who are up here today on a medical debt bill to also be able to address this issue of people being forced into bankruptcy and being forced into making very difficult choices about their own health care or the housing for they and their families, or food, when medical debt is impinging on them. So the governor's going to actually sign that bill, I think, tomorrow. So there continues to be much work to be done on this, but it is so important that the AG's office is holding our healthcare entities accountable and responsible for providing people both the care and the notice of charity care availability. I guess I remember our press conference when this started, and you said that you were worried that St. Joseph's had lost their way. And I shared that worry. I'm hoping that this settlement is something that will take them back to their mission and help them find their way back. This gives them the opportunity to do it, and I hope that that's what we'll see. Thank you again to AG Ferguson and the AG's office for your work.
Thank you, Representative Jenkins. Great to have you back in the AG's office. And thanks again on a successful session. And just a final thought before taking your questions. Representative Jenkins did mention that at that press conference, I did say that, given their history, the Sisters of St. Francis specifically created St. Joseph Hospital to minister to the poor. That was their core mission when they established the hospital. And that in light of the allegations we had through the team's hard work, I did say that, I felt that they lost their way. And, St. Joseph's leadership was not happy with that statement, but it's the truth. It's the truth. That's a hard thing to say, but Representative Jenkins is right. I hope that they take the lessons from this investigation to heart. I think they have, with the fact that we've reached this resolution, which applies not just to St. Joseph's, but all of the CHI Franciscan hospitals. So I view that as a very positive step in the right direction. This is a very significant resolution of many, many millions of dollars and many thousands of individuals. We should never have been at this place. But I also hope, to Representative Jenkins' comment, that this sends a message to the entire industry. This is a focus of our office. This is what Audrey spends her time on, and many individuals in my team. We came at this with a focus back in 2015 that we felt there were challenges in this industry that the advocates here see, that legislators like Representative Jenkins see, and that needed the focus of this office to add that additional resource. This is a team effort. You need employees who do the work, you need advocates, you need folks writing reports, you need attorneys helping out folks access charity care, you need great elected officials advocating proposed changes to law. But those laws are only effective if you have the AG's office enforcing them. That's how it works. That's how it works. We have the resources, we can bring these cases. They're lengthy cases, they're complex, to put it mildly, and they're resource intensive, but I'm just really proud of the outcome that the team's put together here today. And with that, we're happy to take any questions that any of you might have.
Mr. Ferguson,
Yes.
you mentioned that one of the requirements is that those hospitals offer charity care to those who appear to need it. That seems kind of vague. How is that enforceable?
Well, there's an obligation that when someone comes in, you need to inquire. Hey, do you think you might be eligible for charity care? Sometimes what we're saying is, even in our allegations, there are some folks who, even the employees felt were so obviously going to be eligible for charity care, but they were instructed not to offer that up first, but to first ask for payment, right, to make it as difficult as possible, frankly. But there is a legal requirement to inform patients before you ask for payment, before you ask for any form of payment, to inform them of their eligibility for charity care. And that wasn't happening, and that's going to change. Anything you want to add on that? Yeah, Audrey's going to add a little bit to that.
If someone indicates they receive a means-tested public benefit, would be the main way that would happen.
Any other questions?
Yes, you also
Yep.
mentioned that it goes back to 2012. Is
Mhm.
that when St. Joe's began this practice, or I mean, how did we come up with that range?
I'm going to refer to Audrey for that for sure, so go right ahead, Audrey.
That's when we became aware.
Okay. So for folks that this might have happened to before 2012, are they sort of out of the loop, or?
No, they can call any of the Franciscan hospitals, request a charity care application. It's not time barred, the ability to apply for charity care at all.
So one thing we've tried to do, because this is sort of a large, complex resolution, we haven't put every detail into my comments. Some of those details are in the press release. So I'm glad you raised that. The key is whether someone was a patient in one of these hospitals, whether they're insured or uninsured, doesn't matter. If they feel, to Audrey's point, that they would have been eligible for charity care, they should contact the number that we have in our press release. They should do that, and there will be many thousands of letters going out. So there's a process trying to determine who these folks are. Many more thousands of letters go out just to make sure that that process doesn't miss anybody. So we're hoping that the word gets out to folks. If they believe they're eligible for charity care when they're at one of those hospitals, they should absolutely notify the individuals who we list on our press release and the phone number they can contact. So thanks for raising that. Any other questions? If not, hey, we really appreciate all of you being here. We'll hang around if folks have questions one-on-one afterwards, but appreciate your interest.